look, the fundamental thought is this, that before the 1965 Voting Rights Act, this was functionally an apartheid country, because not everybody who lived here got to participate in the democratic self-government of living here, right? Voting was highly restricted, mainly to white men, even after the passage of the 15th Amendment, which said that you couldn't restrict voting on the basis of race. Even after the passing of the 19th Amendment, that said you couldn't restrict voting on the basis of gender. For the most part, only white men had easy access to the ballot, and for the most part, only white men could even dream of being elected to serve in the legislature until the 1965 Voting Rights Act. The 1965 Voting Rights Act, by the way, is the only thing that made the 15th Amendment actually work for black men and the 19th Amendment work for black women.
Yeah.
So if you bring me a law that was passed before all of us get to vote on it, I'm gonna say, why should I care? Why should I care? I'm not saying that we can completely disregard such laws, but I'm saying that in terms of precedential weight, in terms of, as we're trying to understand the histories and traditions of the country, I don't give a damn about the histories and traditions of slavers and rapists. If it's a good law that we now all agree with, not just rich white men, but all of us agree was a good law, we should surely be able to pass it again, as in the case of the 1964 Civil Rights Act. I think the 1964 Civil Rights Act is pretty great, but I will note that it was passed without really consulting black people, and that if you passed a Civil Rights Act with, I don't know, a black Speaker of the House, maybe that law would be a little bit different, even more robust than what they were able to do in 1964. So again, the idea that if we have a good law from our apartheid days, we should be able to pass it again, this time with the votes and opportunity to participate of all Americans, not just white male Americans.